Hi, my name is Audrey and I am from Group 16, which consists of Yixuan, Faith, Chloe, Armel, and myself, of the Contract Law 2 of the April 2020 semester. Now, a contract is said to be valid and enforceable, provided that all necessary ingredients such as offer, acceptance, consideration, intention, certainty, and capacity are present, and all vitiating factors are absent. Vitiating factors are factors which render a contract unenforceable, and amongst them is illegality. Now, the law of illegality underwent a sizable change with the case of Patel and Mirza, and this video aims to discuss the law on illegality prior to Patel and Mirza, the case of Patel and Mirza, and the principles laid down under it, as well as whether the current approach has been settled or clarified under the law of illegality. A contract is said to be illegal when the law forbids its formation or its performance. This prohibition may be derived from statutes, common law, criminal law, civil law, and public policy. Illegality under English law has two general rules. Firstly, the courts would never enforce a contract that is illegal, and this is an inflexible rule with no exceptions, and is found in the case of Holman and Johnson. Here, Lord Mansfield stated that the principle of public policy was ex dolo malo non oritur actio, which translates to no court will lend its aid to a man who finds his course of action on an immoral or an illegal act. And this is also known as the ex turpi causa maxim. He further clarified that in the event that illegality is proven, the court says he has no right to be assisted. Next, the recovery of the advantages under an illegal contract is generally not allowed. However, as will be discussed later, this is not a fixed rule. This is because English law has developed exceptions where one may recover said advantages, and this will be further elaborated by my groupmates. Patrick Salim Atiyah and Nelson Enonchong both suggested two bases for the law's reluctance to interfere in an illegal contract. Firstly, it acts as a deterrent, reaffirming the framework provided by the criminal or tort law in not allowing a person to profit from illegal behavior. Enonchong quoted the Lord Chancellor in Amicable Insurance Society against Boland, who stated that allowing a recovery of benefits is taking away one of those restraints of operation on the minds of men against the commission of crime. Secondly, the lack of interference from the courts also serves to protect the integrity of the legal system. Enonchong explained that it would be detrimental for the legal system to be seen lending their assistance to claimants who have defied the law. Similarly, Atiyah also acknowledges undesirability or jeopardizing the dignity of the courts. And this rationale better explain the court's refusal to sometimes assist even the innocent party in recovering claims. Nevertheless, as Enonchong pointed out, both reasons given can clash with the desirability of preventing injustice to a claimant or a windfall gain by the defendant. Therefore, the law has tried to steer a middle course by allowing a party to recover, even if the contract has been tainted with illegality in certain circumstances. Prior to the decision in Patel and Mirza, this middle course was achieved by applying the exceptions to the general no recovery rule in a formulaic manner. These rules have been adopted in Malaysia through Section 24 of the Contracts Act 1950. Although the word illegality itself is not expressly mentioned, Section 24 states that every agreement in which the object or consideration is unlawful is void. The illustrations under Section 24 covers the various situations where considerations or objects can be unlawful, which includes but is not limited to fraud, sexual immorality, and public policy. This means that under this provision, parties are not able to recover benefits transferred under an unenforceable contract. It could then be noted that the said provision echoes Lord Mansfield's judgment in Holman and Johnson, whereby courts would normally refuse recovery of benefits transferred under an illegal contract. However, as we'll see later, like the English law, this is not an inflexible rule.
Hi, I'm Yixuan, and I'm going to talk about the exceptions of the general rule. The court have developed and recognized a number of exceptions to the general rule, where recovery of money or property will be allowed despite the illegality. The first exception is when both parties are not in pari delicto or not equally at fault. If the plaintiff is deemed to be the less guilty party, he would entitle recovery of benefit conferred. This can be seen in the case of Ohm and Bruce, where the plaintiff was operating under a mistake of fact which rendered him unaware of the illegal nature of the contract. Hence, he was entitled recovery. Recovery was also permitted when a party was induced into an illegal transaction by fraud. This can be seen in the case of Hughes and Liverpool Victoria Legal Friendly Society. Another aspect of this exception was illustrated in Kiriri Cotton Co. Limited, where recovery was permitted when a transaction was rendered illegal under a statute which was enacted to protect a weaker party. The next exception is provided if the claimant can establish a right to possession of the property without relying on the illegal contract. In this situation, recovery will be allowed, and this is known as the reliance principle. The principle was first established in Bow Makers Limited and was subsequently confirmed in Tinsley and Milligan. In Tinsley and Milligan, the court held that the claimant was entitled to recover the interest of the property, even if it arose in the context of some illegality, provided that in doing so, she was not required to rely on the illegality in her plea. Finally, a claimant was also entitled to recover a benefit conferred under an illegal contract if he repudiated the illegal purpose before performance under the contract had commenced. This is called locus ponentiate principle, whereby a party providing payment could withdraw from the illegal contract and recover his payment, which was illustrated in Taylor and Bowers. This approach was also applied in Tribe and Tribe, where the claimant, a father, was seeking to recover the property transferred to his son, with the objective of concealing his interest from a potential creditor. He was allowed to the benefit of the exception, and Millard Lord Justice, in his judgment, expressed that justice is not a reward of a merit. Therefore, restitution should not be confined to the penitent. Instead, it is sufficient that a party voluntarily withdraws from an illegal transaction.
The difficulty with this exception was shown in Collier and Collier, in that its operation was rather arbitrary. This was pointed out because the ability to recover depended entirely on chance. As Coote pointed out, the real difficulty lies in the arbitrary, all-or-nothing character of the common law governing illegal contracts. If a man transfers property to his wife or children, or a mother to her children, all with the motive of defrauding creditors, assuming the illegality is carried out so the locus ponentiae principle does not apply, the property will be unrecoverable. However, if the transaction is made between friends or strangers, the transferor can exercise recovery. There is no rationale for treating these circumstances differently, as there is no material distinction. If one intends to defraud his creditors by transferring his property to someone else, of what significance is the nature of his relationship with the other party? The reliance principle also allows one party to gain a windfall. In Tinsley and Milligan, it may be said that Milligan gained a windfall, one she would not have gotten if she didn't own up to the government for deceiving it. This, as observed by Lord Kerr and Patel and Mirza, seems to condone the illegal agreement between the parties, thus going against the very function of the illegality doctrine to protect the integrity of the legal system. Furthermore, the courts take no account of the value of the windfall given, leading to the substantive unfairness and disproportionate results. It is mentioned by Lord Gough in Tinsley and Milligan as allowing unmeritorious or mala fide claimants to recover property regardless of the seriousness of the illegality. The Law Commission has noted that, as the reliance principle takes no account of the practical impact of the defense on the claimant's property, this may result in an excessive and disproportionate penalty being imposed. Thus, in failing to account for the severity of the illegality, the integrity of the legal system may be compromised. Due to these inherent problems, the reliance principle was subject to scrutiny by the Law Commission. It wished to see a more transparent, policy-driven approach to the issue of how illegality should impact upon claims, and considered that cases such as Gray and Thames Trains and Stone and Rolls and Moore-Stevens showed that the common law was moving in this direction. It recommended direct statutory intervention to abolish the reliance principle, but to date, there has been no such intervention. However, Gloucester LJ, a Court of Appeal judge in the case of Patel and Mirza, approached the reliance principle in a more liberal manner, with public policy at the forefront. In her view, it was necessary to consider whether the policy underlying the rule would suffer by allowing a claim for restitution. And in addressing this issue, factors such as the connection between the illegality and the claim and the disproportionality of disallowing the claim to the unlawfulness of the conduct were considered. Conversely, Lord Justices Reimer and Voss were satisfied that the reliance principle still held good and proceeded to apply it in the Supreme Court case of Hunga and Allen. They stated that the test in Tinsley continued to carry maximum precedential authority despite the criticism it has attracted. The law on restitution in relation to contracts tainted with illegality underwent a sizable change in Patel and Mirza. The facts of the case are as follows. Patel had given Mirza £620,000 to bet on a bank's share price using insider information, something that they both knew amounted to conspiracy to commit insider dealing. Patel thus sought to recover the money from Mirza, claiming breach of contract by Mirza and/or unjust enrichment. Mirza sought to raise the defense of illegality. At first instance, the High Court applied Tinsley and Milligan in declaring that Patel's claim was unenforceable as he had to rely on his own illegality to establish it. The decision was appealed, and the Court of Appeal held by majority that the High Court judge applied the reliance principle correctly. Nevertheless, it allowed Patel's claim based on the locus penitentiae exception. The decision was appealed again, and the Supreme Court unanimously dismissed Mirza's appeal. However, there was a stark difference in the manner in which they came to their conclusion.
The majority view, led by Lord Towson, rejected the traditional rule-based approach and opted to apply a flexible, multifactorial approach based upon public policy. They also declared Tinsley and Milligan as no longer being a good law. Additionally, there was no need to consider locus poenitentiae exception. Their decision was based on public policy at play and proportionality. They conclude that this was not an exceptional case where Patel's claim should be dismissed on the ground of public interest. In contrast, stuck with the traditional rule-based approach, they used the reliance principle as the starting point for prima facie rejecting Patel's claim, but held that the locus poenitentiae exception applied. Additionally, Lord Neuberger also took the rule-based approach but recognized the majority's view as being appropriate in some circumstances which were never laid out.
The approach that arose from Patel and Mirza was referred to as the trio of considerations. Lord Towson borrowed heavily from Professor Andrews Burroughs' Restatement of the English Law of Contracts in formulating this new approach. Under the trio, the key question was whether allowing restitution would damage the integrity of the legal system. This depends on whether the purpose of the prohibition would be enhanced by a refusal of claim, whether denying the claim affects another relevant public policy, and whether denying restitution would be a proportionate response to the illegality committed. Within the trio of considerations framework, numerous factors may be relevant, such as the seriousness of the illegality, the centrality of the illegality to the contract, whether the illegality was intentional, and whether there was disparities in the parties' respective culpability. Before coming to the question of whether the new approach has clarified or settled this area of law, it is imperative to ask if this is a new approach at all. Lord Towson's observation that the trio of considerations can be found in existing case law seems to suggest that no revolutionary step had been taken in its adoption. Hatteran, therefore, makes a valid point in considering the new approach less of a revolutionary change and more of a structuring and refining of the existing law. The argument that the new approach is not as new as it seems, is only furthered when investigating older cases and applying the new approach to them. For example, the outcome in Tinsley and Milligan would likely remain unchanged even if the new approach were to be applied. Looking through the lens of public policy, the immense windfall that would arise in allowing Tinsley's claim would not in any way uphold the integrity of the legal system, but rather encourage the public to mimic the happenings of this case. Additionally, the proportionality of the total denial of a claim for partial ownership based on trust is dubious at best. In fact, Patel and Mirza itself, through application of the reliance principle, would likely yield the same outcome. This is because Patel would not have had to rely on his illegality in order to establish a claim. The illegality of insider dealings would play no part, as it would merely be regarded as a restitutionary claim for a bet that never materialized. Additionally, even if the reliance principle were to be established, the locus ponentiae exception would be applicable. This stance is further evidenced by the fact that the full panel of 9 judges in Patel and Mirza unanimously dismissed the claim, regardless of whether they applied the new or old approach. This is in line with Lord Clarke's observation that the reliance principle would have yielded a similar outcome as the proposed new approach. Lord Sumption's words that justice may be done without taking this revolutionary step thus appear to ring true. Overall, the newness of the new approach can be debated. Nevertheless, whether or not the one chooses to regard it as new, the current approach presents a distinct set of advantages and disadvantages. The explicit emphasis on, and the need for, proportionality in the new approach should be commended. Though it's not an entirely new consideration, as seen in the court's allowance of restitution under the exceptions, the new approach legitimizes the overt consideration of proportionality. This, in theory, accommodates a balance between a mechanical application of the no-reliance principle and a self-righteous rejection of an otherwise valid claim. The issue of one party gaining a substantial windfall, as was the case under the old approach, can also be mitigated to a great extent. In that respect, the new approach should be lauded. The main criticisms of the new approach seems to be that it is too flexible, to the extent of underpinning the requirement for legal certainty. This is because the new approach is heavily reliant on public policy, the meaning of which is shrouded with skepticism. This view is supported by Hacharan, who questions the meaning of public policy, as well as how courts are to identify it. As such, the outcome of Patel and Mirza can be seen to be an evaluation of a large number of incommensurate factors, which leans heavily on a judge's visceral reaction. Similarly, Virgo expresses that the new approach is an arbitrary choice with a high degree of judicial discretion and no guidance. The court's reluctance to supply an explanation as to how the trio of considerations was applied in Patel and Mirza shows this lack of guidance. The words of Judge McLaughlin in Hall and Herbert are regarded as being of particular importance. She expressed the view that public policy should not replace the ex turpi causa maxim, as it would provide no proper guidance regarding when judges should exercise this draconian power, and upon what grounds. The replacement of the ex turpi causa maxim would thus be akin to trading one label for another without coming to grips with the fundamental problem. This is in line with Judge Tukey's view that once we are in the realm of public policy, we are in a rather shadowy world.
Justice Burrow regarded public policy as an unruly horse, whereas Lord Denning considered it as being capable of being controlled by good men in the saddle. It is clear that the majority in this case regarded themselves as such good men in electing to apply the new approach as a means to allow for greater flexibility. This affords a great deal of freedom for judges to decide cases on what would be equitable. However, as pointed out by Lord Clarke, equities are important, but there are pragmatic limits as to what the law can achieve without becoming arbitrary, incoherent, and unpredictable, even to the best advised citizen. In fact, the minority as a whole expressed concern over the new approach's potential lack of certainty. As pointed out by Hacharan, it has the potential to further extend the uncertainty surrounding this area of the law through its discretionary nature. Additionally, the plight of legal advisors in advising their clients would almost certainly worsen as a result of this uncertainty. Burroughs acknowledges the potential decrease in certainty, but argues that the new approach would lead to a higher degree of transparency, thus achieving certainty in that manner. However, the new approach is still in its infancy stage, and so it remains to be seen if this will be the case. In Malaysia, the Court of Appeal in Pang Mun Chung favored the law set out in Patel and Mirza to the extent of departing from precedent set out in the Privy Council case of Saudara Ali. It was expressed that the courts are now spared from having to devise piecemeal and contrived exceptions to previous formulations of the illegality rule, thus bringing an end to the fragmented state of the law. Commentators in New Zealand, who apply an exclusively discretionary approach, suggest that following Patel and Mirza would provide their courts with a structured discretion. This echoes Lord Newberger, who observes that the approach laid out by Lord Tolson is structured and not akin to a practice of discretion. Although, Burroughs argued that the approach does not structure the discretion at all, as there is no sequential approach. Structure, in Burroughs' view, would be akin to that of Singapore, who rejected the Patel and Mirza approach to illegality, instead applying a two-limb approach. Firstly, courts are to ascertain if the case concerned a prohibited contract, whether there is a statutory illegality or the contract falls under common law public policy. Where contracts are not illegal per se, but nevertheless involve a commission of a legal wrong, the courts consider a range of factors similar to those considered by the majority in Patel and Mirza under the trio considerations. Secondly, the proportionality principle is applied to determine if an illegal contract is enforceable. In rejecting Patel and Mirza, but applying a similar approach, the Singaporean courts seem to support Burroughs' opinion that the approach laid out in Patel and Mirza, contrary to Newberger's view, is not structured. Overall, the Commonwealth appears to be divided in its opinion on Patel and Mirza, with countries such as Malaysia and New Zealand granting positive reception, whereas Singapore disapproves of it. As previously mentioned, it is arguable that Patel and Mirza is not a new approach per se, but merely a refining and restructuring of the law. However, to what degree has its claimed refinement actually materialized? The uncertainty caused by the abundance of discretion afforded to judges, combined with the apparent lack of structure provided in the new approach, means that its application leans substantially on the whims and interpretations of the judge of any given day. This gives rise to the possibility that the application of the new approach will vary wildly from case to case. In light of such volatility, how then can one say that the law has been clarified? It is on this basis that our group argues that the law post-Patel and Mirza has in fact not been adequately clarified. With regard to whether the law has been settled, our group argues in the negative, as how can a principle be settled when we are not yet sure what it is? A notable merit of the new approach is its overt consideration on proportionality. However, as stated prior, the previous approach already considers proportionality in its application, albeit indirectly through exceptions to the extra causa maxim. One would hence be justified in thinking that the previous approach ought to have just survived. With that being said, however, we feel that it would be wrong to look at the new approach established in Patel and Mirza purely as a step in the wrong direction. Burroughs considers Patel and Mirza not to be a be-all, end-all, but rather a stepping stone for the law to develop. Upon further contemplation, we too are inclined to agree. Perhaps the way forward would be to structure the tree of considerations in a manner that minimizes judicial discretion. An adequate illustration can be seen in the method used in Singapore, whereby the first two limbs, the underlying purpose and conflicting policy considerations, are the controlling factors, and the third limb, proportionality, is subordinate and therefore only applied when no resolution is met by applying the first two limbs. Through this structuring, perhaps the unruly horse of public policy may be kept in control. That concludes our video presentation. We as a group thank you for tuning in, and we hope you learned something, and most importantly, enjoyed the video. That's all from me, and once again, thank you for listening.